The September meeting of the Troy Zoning Board of Appeals to order. And before we go into the agenda, we have a brief overview I'll read about what we do here and what our function is. The Board of Zoning Appeals is a group of 7 of your neighbors or peers appointed by the City Council to pass judgment on requests for variances and other matters that are brought before them. A variance is a relaxation of the literal provisions of the zoning ordinance. Petitioners must indicate a hardship or practical difficulty running with the land that will warrant the granting of the variance. The board will hear the items in the order that they appear on the agenda. When an item is called, the chairman will verify that the petitioner is present. Then the city administration will summarize the facts of the case. The petitioner will then be given an opportunity to address the board to explain the justification for the action requested. After the petitioner makes their presentation and answers any questions that the board may have, the chairman will open the public hearing. Any person wishing to speak on the request should raise their hand, and when recognized by the chairman, come up to the podium and then be sure to sign in on the sheet that's provided up in front. The speaker should identify themselves with their name and address, indicate their relationship to the property in question, for example, a next door neighbor or they live behind the property, and then state whether they are in favor of or opposed to the variance request and give their reasons for that opinion. Comments must be directed through the chairman. Comments should be kept as brief as possible and closely pertain to the matter under consideration. Only one person will be recognized by the chairman to speak at one time. After the conclusion of public comments, the chairman will close the public hearing. Once the public hearing is closed, no other public comment will be taken unless in response to a specific question by a member of the board. The board will then make a motion to approve, to deny, or to postpone action on the request. In order for the request to pass, a minimum of 4 votes for approval are needed. If the request is not granted by this board, the applicant does have the right to appeal our decision to the Oakland County Circuit Court. And I will also at this point introduce the members of the board and the city staff that are here tonight. On my far left, your right, is Glenn Clark. Next to him is Michael Bartnick. Next to Michael is Thomas Stratt, who is not only a member of this board, but is also a liaison to the Planning Commission. I'm Dave Lambert, the chairman. Next to me on my right is Alan Neal, who is the vice chairman. Next to Alan is Bill Fisher. And then finally, the last member of the board is Ken Courtney. Joining us tonight from city staff is Paul Evans, who's the zoning and compliance specialist from the city. And then last but certainly not least, Susan Lancaster, an assistant city attorney. And with that, we'll ask Mr. Evans to read off the roll call.
Thank you, Mr. Chairman. Mr. Clark.
Here.
Mr. Courtney.
Here.
Mr. Fisher.
Here.
Mr. Neal.
Here.
Mr. Lambert.
Here.
Mr. Stratt.
Here.
Mr. Bartnick.
Here.
All are present tonight. Thank you for reading that off. Next on the agenda is the approval of the minutes. We have the minutes for both the June 21st and August 16th board meeting. Someone like to make a motion to approve or any corrections that anyone wants to make? Mr. Courtney?
So move.
Mr. Courtney has moved to approve. Mr. Clark has seconded to approve the minutes from those 2 meetings. Any discussion or correction to those minutes? Seeing none, we're ready for the roll call on that.
Mr. Courtney.
Yes.
Mr. Fisher.
Yes.
Mr. Neal.
Yes.
Mr. Lambert.
Yes.
Mr. Stratt.
Yes.
Mr. Bartnick.
Yes.
Mr. Clark.
Yes.
The minutes are approved from the June and August board meetings. Next, approval of the agenda. Are there any changes to the agenda for tonight?
No changes, Mr. Chairman.
Okay, Mr. Stratt has something that he wants.
No, I
Okay.
approve.
Okay.
I wanted to approve it.
Okay. Would it be appropriate to take a motion to approve the agenda as presented, or is we just accept it as
Just accept it,
presented?
no
Okay.
changes.
All right,
That's
okay.
fine. Yeah.
All right, then, with that, with no changes to the agenda, the hearing of cases. The first one is a variance request from Anthony P. Martin and Nadia H. Martin at 3954 Anvil in order to allow an existing detached accessory building to remain in the side yard. And as it says here in the agenda, accessory buildings are permitted only in the rear yard. Mr. Evans, would you like to present the information to the board?
Thank you, Mr. Chairman. The subject property is located in a neighborhood south of East Waddles and east of John R. Road, specifically at the corner of Waddles and Anvil, outlined in the red on the overhead. The property and all surrounding property is zoned single-family residential. The subject matter of today's request involves the location of an existing, recently constructed shed. Earlier this year, the city building department approved construction of a shed in the rear yard of this property. The applicant constructed the shed, but final approval was for the construction could not be given by the building department due to a discrepancy between the construction prints and the location of the actual constructed shed. In this drawing here, this is an as-built of where the shed is, and the discrepancy is that the shed is built primarily towards the left side of this red line. Now, this red line delineates the separation between the rear yard, which is to the right of the red line, and other yards, which are to the left of this red line. Now, the city code allows sheds on residential property, but they can only go in rear yards. So in order to maintain the existing location of that shed in primarily not the rear yard, he would need a variance from this board tonight.
So in essence, that shed would have to be moved to the right of that red line?
That is correct.
Okay. Any questions from the board for city staff? Mr. Bartnick.
One of the things that was changed, thank you, Mr. Chairman, if I could ask a question. One of the things that was changed in the new amended ordinance were drawings to show us locations of front yards, heights of buildings, et cetera. Is there a photograph or drawing that shows or delineates the legal definition of the rear yard?
In the ordinance?
Right.
Yes, I could probably put that in the overhead in just a moment here for you.
Do you need a few minutes to look that up, Mr.?
Yes, please.
Any other questions from the board while Mr. Evans is looking that up? Mr. Courtney?
Yeah, I have a question of Mr. Evans also.
Okay.
I don't know if he wants to handle it at the same time, but there's a drawing in the agenda that shows the shed in a different location than the actual build. It shows what's up there at the present time. I assume that was the one that was submitted for permit.
Right, that was the one that accompanied the permit.
Okay, thank you. Which is different than the as-built, of course.
Right.
Mr. Evans appears to be pretty good at multitasking here, so anyone else from the board have a question for him while he's trying to pull this information? Oh, he looks like he has the information right there, so.
Yeah, this is out of the zoning ordinance.
If I might ask another
Okay.
question. So where does it show that the rear yard starts and finishes on the drawing there?
According to that drawing, I don't know, well, at the end of that line. Now, we do have another portion of the ordinance here. That the rear yard, here's the definition of rear yard in our ordinance, Mr. Bartnick. An open space extending the full width of the lot, the depth of which is the minimum horizontal distance between the rear lot line and the nearest line of the main building. So interpreting that or translating that to the actual site, this is the rear lot line here, this black line to the right of the photo. It's the distance between, or the area between this line and the nearest point of the main building. And this building is L-shaped in this area here.
Where are the side yards under the ordinance?
The side yard would be, the side yard is a yard between the front yard, which has a similar definition from the front property line to the nearest point of the main building. So the side yard is the yard between the rear yard and the front yard. So by definition, this area is considered a side yard.
Mr. Chairman,
Yes, Mr. Courtney.
if I may, the drawing that you showed us before from the agenda, from the ordinance,
Yes, sir.
it appears to have a line going through a building. It appears to me that the line goes directly through a building. Is that attachment supposedly a garage?
It doesn't really stipulate.
Okay, so
I mean,
I
it
think-
it is what it is.
Yeah, Mr. Courtney, I think what those are just kind of like showing the width of the piece of this front yard and the rear yard, rather than actually going through the house like that. I think
When we redid the ordinance, we tried to add some more visuals to
if it's
try to
something at the
clarify.
back of the, if it's at the rear, if the rear yard comes off from the main structure, what's the attachment if it's not part of the main structure, right?
I'm
I
not
would
sure I
expect-
understand your question. Is that a question for me
That
or?
line appears to go through a building. And if everything behind it is to the left is rear yard, and everything to the other side is the,
Well, I'll tell you, unless the board wants to determine otherwise, in this case, the definition of rear yard is the definition and the application that the building and planning department applies to determine the location of the rear yard.
okay.
So that was,
Well, can you
That
show
was-
me on that other drawing where the rear yard actually is?
on that other drawing,
Yeah.
Ken, the drawing is what it is.
No, in the ordinance. In the ordinance.
Yeah.
I mean, if you're,
My answer to that is it is what it is, Ken. I mean,
Yeah,
you
but
can
I'm
see the
still
same
like-
drawing that I do, and the department interpretation is this specific language here,
no, go to the drawing.
okay?
instead.
Okay?
Okay, that line going from north, northwest to southeast, is that the line that's telling me where the rear yard is and
This
what
line?
it isn't?
Yeah, yeah.
No, or is it just, oh, okay, I'm sorry. I'm reading the line, it's not the line, it's the area behind, the area to the north is the rear yard, the area to the south is the front yard. Okay,
Okay,
that's what,
all right.
okay, I'm with you now.
Good, okay.
No, I was reading that different, and it was-
Gotcha.
I couldn't understand what in the heck was happening.
I was a little confused there too, but,
Yeah.
okay, sounds good.
Okay.
All right.
Mr. Neal,
I just wanted to add one item, and you kind of got there. I was going to point out for something. The best way I can describe it is if you look at that additional line that runs through the word rear and yard, for example.
Yeah,
At the end with the little arrows, usually it's self-explanatory, but it's missing it in this case is that if you look at a site plan, sometimes it'll have like a dimension. It would say like 72 feet or something of that nature. The intent, I'm sure, there is to show this spatial difference from the front edge of the property, let's say by the curb, to the house, that's front yard and whatnot. But it almost looks like you're subdividing the parcel. And I think by not having that additional feature like a dimension, it's adding confusion.
yeah, the arrows,
Yeah, the arrows are on there. so-
yeah,
Gotcha.
yeah,
Okay.
But,
that's good.
food for thought, I guess we could take out the arrows or something.
any more questions for city staff? Mr. Clark?
Thank you, Mr. Chairman. Mr. Evans, can you please, maybe you can't explain, but maybe you can help me with this. On page 23, the red X'd out shed or box,
Yes.
was this the original structure that is gone, and now this new shed, which apparently I'm understanding has been up since the summer, replace that? I mean, what is the red X'd out?
Originally, the applicant wanted the shed in that location,
Oh, I see.
and for clarity, I put that X there so the board understood that the shed on the left was the one we were talking about. And I think it was pretty clear, the applicant was aware that we couldn't approve it there, but we could approve it in the other location.
Mr. Chairman, one more question, please. Mr. Evans, if you could, I don't know, help, and maybe Mrs. Lancaster could consult on this question, but it just seems to me that I can see how the ordinance conflicts with what the property owner did here, but at the end of the day, we're a very developed city, and we have many, many buildings and many large commercial buildings which are not all square in nature. You know, there's S-shaped buildings in this town, and complex, you know, buildings with courtyards and so forth, and that may not be attributed to residential buildings. But what I'm trying to get at is clearly, if you could maybe go back to the original one here, yes, this one. Clearly, if the home came completely out and the shed was just pushed back a little bit, that would be completely, you know, within the ordinance, from what I understand, in the rear yard. But seems to be a gray area in that clearly there's a home in front of the shed, so it's not in the side yard, it's in the backyard and in the side yard because of that cutout in the structure. So I guess what I'm asking is, like, how does the ordinance regarding similar outbuildings apply to commercial buildings which may not be generally shaped in a rectangular or a square fashion? Meaning, wouldn't that be, I imagine there has to be something within the different zoning for commercial in Troy that would apply to allow property owners to do whatever they need to do, you know, for industrial storehouses and so forth. Are you getting what I'm trying to say? It just seems like if the standard is this, because of this cutout portion of the home, and clearly it's hidden from the street because it is in the back of a portion of the building. It may not be in the back of the building. It's certainly in the back of, you know, that southern portion of the house. Wouldn't commercial buildings have some sort of dissimilar rules applying to them?
Yeah. They have rules, and I didn't come prepared tonight to answer those. I could, given some time, but in the interim, perhaps we could hear additional questions from the board and take testimony from the applicant as well. Perhaps the board will determine that regardless of how the city addresses commercial buildings, maybe there is a valid, maybe there isn't a valid reason to grant a variance for this tonight.
Mr. Chair,
Yes.
if I could add to that. I think, if I'm understanding the question correctly, when we design ordinances, we can't possibly consider every situation that would ever be concerned due to creative designs, due to changing designs with architecture. So laws are written generally to cover things like front yards and backyards, and most zoning officials kind of can interpret what that means. So basically, I think you have to stick to the residential and understand that these are general laws, and if you get a situation, these are always, in fact, some of the factors that are written into what you can consider tonight might be some of the factors that have come up in this. And that's why there's an appeal to the Board of Zoning Appeals, because these are the kind of cases that you have to decide if this is just a technical violation based upon a hardship or practical difficulty. So that if I'm thinking of what you're asking, if I've gotten that answer correctly, we
Yes,
just
ma'am.
we couldn't possibly conceive of every architectural design. So they're written with a general pattern, and anything that's beyond that we didn't conceive of, they can come to the board and ask you to look at it.
Any more questions for staff? Mr. Bartnick?
I do have a few more questions. The thing that's troubling about this, obviously, is that one or more individuals in the building department apparently had the same struggle that we're having, because the record shows that at first inspection approved the location as being completely in accordance with the ordinance, and then another inspection 5 weeks later said no. So I'm looking at the definition of the rear yard and the drawing in the ordinance at pages, well, you had them up on the screen. B, the rear yard, is the text description, but then the drawing appears to show a building that has, the smaller portion is also the rear yard, the arrow, can you put that back up there, the
Yeah.
drawing from the ordinance?
I'm gonna get it, and then I'll put it up there. Just have to get to the right section here.
I guess while we're looking at this photograph here, where I'm getting at is, what is the little L-shaped part that's immediately behind the house? It doesn't appear to be any yard, according to the strict definition of the side yard and the strict definition of a rear yard.
That's a good point.
Because the definition of a side yard, on the as-built, is there a way to leave both of them on the screen? Okay, it looks like the as-built structure is a single-family home with an attached garage. And comparing those two photographs, the drawing with the aerial photograph, the side yard on that house would end at the garage. Yet the rear yard under the ordinance does not end at the back of the garage, but rather ends at the back of the house. And the front yard is to the front of the house. So on this particular property as dealt with, and again, recognizing that ordinances and laws can't be drafted to take into account every situation, that little box there where the shed is located doesn't appear to be in anybody's yard. On the other hand, another way to interpret it is this is a corner lot, and the second and third sentences of paragraph B for a rear yard, if I'm reading that right, one of the non-front yards shall be considered a side yard and the other side shall be considered a rear yard. In the case of a corner lot, the rear yard shall not extend into the front yard. So it seems to me that there's an additional interpretation of the ordinance here to this house, is that the yard along Waddles is not a second front yard, but rather is a rear yard that shall be considered that can be, one of the non-front yards shall be considered a side yard. So if you consider the yard on Waddles as to be a side yard, the next sentence says in the case of a corner lot, the other side shall be considered a rear yard. So I'm wondering if the first inspector was correct, and that by definition of the ordinance, the shed is in the rear yard, and there's no need for the variance. Am I confusing issues for the board or clarifying them for the board?
We believe, in talking to the building official who approved the original plans, as well as our re-review of this matter, that our interpretation would be that, as indicated here tonight on this drawing, certainly if the board believes that our interpretation isn't correct, or perhaps a variance is warranted, certainly the board has the ability to address that as part of your findings. Certainly, had staff believed that there was any way we could perhaps reasonably avoid not requiring him to come for a variance, we wouldn't have asked him to come here tonight.
Thank you.
So, Mr. Bartnick, that might be something to keep in your back pocket as we deliberate more on this. Okay, Mr. Stratt.
I just had one question. What is the rear yard setback requirement?
45 feet.
I noticed that the drawing is plus or minus, so it indicated that. And I noticed that appears like a fireplace that projects back into that building, based on what I thought I saw in the drawing or on the one of the photographs. I don't know which one it was. But at any rate, we don't know exactly what the setback, but it is a 45-foot setback.
Let me verify that just to make sure.
I'm looking at the aerial on page 25. But it looks like it's close enough. It's a plus or minus situation. We don't know where exactly it's at without it being really surveyed.
Tom, it's a 40-foot rear yard setback would be required
40? Okay.
for a house.
Okay, that just, thank you very much. No, that answers my question.
Mr. Neal.
Satisfies my,
Mr. Neal.
I have one question for staff, for you, Paul. It's somewhat of a timing or phasing issue. The drawing on page 23, from reading through the materials before I came and then now and seeing the site and such, I want to make sure a couple of things before I ask a question. Where it's X'd out is where the applicant wanted the shed, which I assume at the counter or so was explained to him or her that it could not go there. Is that correct?
Presumably, but maybe the applicant, because I didn't have those discussions with the applicant.
Now, the building structure that's shown on the left side of the drawing, where it's showing that it would be behind the most rear wall of the building, let's say.
I believe in discussions, yeah.
Is that what was submitted to show where it was going to be built?
The building official tells me he wrote that on there, and it was his understanding, or at least he believed that it was clear enough that he was under the impression the permit was issued would have that building no closer to the road than the back of the house.
Okay. Is that drawing drawn by the applicant or by the building official?
The building official drew that in.
Okay. So this is not drawn by the applicant. Just want to make sure that's clear.
And he can confirm that for you, because actually I wasn't there.
I understand. I mean, I don't know what your nature
Yeah.
of discussion was. It's for me, a big aspect of the issue is this drawing and the dimensions very much go with the permit. And it's still very gray to me because this is not what was submitted necessarily by the applicant.
You may hear the applicant address that issue tonight.
Okay, I guess we'll wait and see.
You may.
what we get then.
Yes.
Okay, Mr. Courtney.
Yeah, before you leave this, do you think it was the building inspector that put in the dimensions that are shown, the 10 by 10?
Yeah, Steve Burns told me he did put that in there.
Okay, and then on this drawing, we show 10 and 10. And is the dimensions that he did build it at were the 10 and the 10?
Yes.
Okay, so what he was given by the building inspector here, if he looked at the dimensions, he would have built it right. If he looked at the location, he would have built it wrong.
Well,
Because the dimensions do say 10 and 10, and he does have it built at 10 and 10.
you may hear the applicant tonight say something to that effect, but we'll wait for them to speak.
Thank you.
Any more questions for staff? Mr. Barnick.
I have a question. What is the difference between the legal effect between having a determination made that there's really no need for a variance request to be made versus acting upon facts that may require a variance request? Because I'm really troubled by that first question that I raised a few moments ago, that perhaps this should not even be in front of the board, that it's a mistake that was made internally, and once it's brought to their attention, the matter is not necessary to come to in front of the board. Because there's could be precedential value effect to a decision adverse or in favor of the applicant.
Mr. Chair, if I could answer that question. Courts would look at the equities. Certainly, this is not the first, it might have been a mutual mistake of the parties. Doesn't necessarily have to be finger pointing. But if a mistake was made, it's necessary, there's no provision to administratively approve this. It has to come to the board. Otherwise, it might affect mortgage surveys and things of that nature, because if it's not approved, it becomes a illegal non-conforming use, versus if it's approved, it becomes a legal non-conforming use. So in terms of answering your questions, as many permits as the city gets, rarely does this happen. But we're not the first to say that mistakes happen. I think the board has pointed out a lot of very good questions tonight about when you have hand-drawn diagrams, it's a little harder to read. And as again, not to finger point, in terms of your question specifically, what would a court do with this? I have no idea. If it's a mutual mistake of fact, that's helpful. However, courts do look at equities.
Thank you.
So your advice to us as the attorney for the city is that you believe we should make a position on this issue and not allow this to be handled administratively by staff?
I think it's better because it becomes, if you don't make it from this board, it becomes an illegal non-conforming use, and that's not fair to anybody because we need, that's the definition. What you do here actually creates many legal non-conforming uses, which is why, one of the reasons why we need you, because otherwise mortgage companies take that into consideration. They want to make sure it's legal. It comes up in condemnation cases. There's a lot of reasons why it's important that this board decide that.
Thank you. You have a question,
Just
Mr. Neal?
one question. Can you define what you meant by equities? I just want to make sure I understood.
Sure. The court will look at the city and what they did and the petitioner and how the petitioner is situated. I don't know anything about this petitioner, but they'll look to see if he's a developer versus a homeowner. And the court will try and create a remedy that is fair to both sides. And anytime you have government versus, I will say, the little guy, sometimes the court will see the little guy's position.
Okay.
Is that a fairly?
Yeah,
Okay.
that explains it. I understand now. Thank you.
Any more questions for city staff by the board? Seeing none, we'll invite the petitioner or petitioners to come forward. I don't know if it's the Martins or come on up and make your presentation to the board. Make sure you sign in the front. And sounds like if you don't have anything prepared, there's lots of questions the board has for you. So.
Okay. My name's Anthony Martin. I own the house. Do I need to
Yep,
sign?
sign in there, please. Yep.
And he's asked me to speak on his behalf.
Okay.
My name is Santa Isho. I'm a friend of the family.
Okay, and be sure you sign in as well then.
Anything new? Anything new that could be added?
Yeah, I guess the one thing, with the number of questions that have been asked here, if you present some new information here for us or answer any questions that staff wasn't able to answer
Well,
as
there's
well.
A few you guys had it right on the money, kind of like, because first of all, the city inspector drew that out, and he's the same one that passed it. And he didn't tell me anything about being behind the furthest part of the house. He just told me 10 feet from each wall, which that's where I put it.
May I present you with some
Sure,
pictures?
yeah.
These are different angles. And if you look at the drawing said 10 feet from the side of the side area, which is the family room, and it draws a line 10 feet from the garage. And that's exactly how it was constructed, 10 feet from each wall. Now, as far as the city code, I'm not going to argue with the written part, but when Mr. Martin went to the city, he relied on the city planning to let him know, and he was told that he couldn't erect it on a main road, which was Waddles. That was something that he was told, and that's why they couldn't do it on the other side. He preferred to have it over there because of the trailer he has in his backyard. So I don't know if that's an ordinance, but that was his preferred location. And I apologize, I'm looking there because he's the one that brought that up.
And if I was to move the trailer away and have to put the shed back there, which I would have to demolish it and buy another one, which I don't think I should be held responsible for that. And then the trailer would end up being where that shed practically is.
I'm sorry.
And we're only here because of one neighbor have complained.
And I also want to present some pictures. Now, previously, he had asked, what if I purchased 2 small sheds and put them against the house? And he was told that was against code. Anything that's back there must be 10 feet away from the house. Those are pictures of his next-door neighbor's backyard, and 6 inches off the ground. And those are directly, as you can see in the picture, next to the house. And in the letter that was written, that was mentioned where, how can the person complaining be the person that has this in his backyard and no one's acting up on that?
So, Mr. Martin, one quick question for you is, and this has kind of been brought up here, but just to make sure to keep us focusing on track here, one of the challenges you have is because you have a corner lot there, so trying to figure out a good place to put your shed is a challenge because of that configuration of your lot. Is that true?
Yes.
Okay. Right. Any more?
I just thought I was doing the right thing.
Okay.
And where I wanted to put it, they told me I couldn't. He drew it out there, told me 10 feet, 10 feet, I put it there.
Right.
And I apologize, but the picture up there has the circle. The circle kind of is taking away from where it says 10 feet from this side of the house.
Yeah.
This is the drawing that he had with his paperwork. So, as you can see, it's not saying 10 feet this way, it's 10 feet this way. And I believe part of what I think Mr. Clark was asking is where does the side yard start? Now, had he done it on the side of the garage, that would have prevented access to the backyard. And I believe when they were drafting that, because of the odd shape of the house, that would have been considered a side yard, and that would have been a problem putting a structure there and having access to the backyard. Another thing I mentioned in the letter, I'm not sure if you had, I know one person had a question about the letter, but one of the things I mentioned in the letter is he has the trailer, and if he has to bring that out, they are on a street where there's a school down the street. And that would be a hardship for the children that are crossing. That would be a danger because cars pulling out of driveways may not see the children. It may block the access, the visual access to the buses that have to drive down the street as well. And as far as the shed not being erected on Wattles, if you look at if you zoom back, I think it was initial picture with all the addresses on it, the house directly across from Wattles has a shed that's it's right across from him, has a shed that's right by the one behind it. That's a shed right off the street. So he was prevented from putting it on that side because that's the ordinance, yet, if you look at it, there's another one there that's not where it's supposed to be.
You have to understand, excuse me.
Go ahead, Mr. Stratt.
You have to understand that we can only act on certain conditions that really are required as far as whether or not we can actually approve the variance or not. I don't know if you were told about those conditions, or
Yes.
have you?
Yes,
So
and
really what you should be answering is no questions. Now, it appears to me that there is a hardship in respect to it being a corner lot. Is that correct? Is that what I'm hearing you say?
Correct. That is one of them. That was one of the things that I mentioned. But the reason I brought that out is because they gave me a copy of the criteria that has to be present in order for the variance to be granted. And part of the criteria, I think it's in part 2.
Answer those questions then
Yes,
for us.
and that's part of the criteria. They said it could be mentioned that there are others in the neighborhood that have the same thing I'm being prevented from having in my backyard as well. I did mention the hardship because of the shape of the house. I mentioned the hardship because of the trailer in the back of the house.
That's self-imposed. That's
Okay.
not a condition as it exists. That's self-imposed.
Okay.
That is not a condition that we would be considering. What other?
And the hardship of not being able to put it on the other side of the yard where they initially wanted
That's
it.
part of the condition of the site, corners. They have a site, corner condition site, so that prevented you from doing that, right?
Right,
Okay.
right. But I'm saying the reason I mentioned the others is in the criteria, it states that if, let me find it. (2E) is where I speak of other houses having it, and that's the only reason I brought that up, where the house across the street directly has it.
Okay, thank you.
And the drawing was drawn by the city official. It's not something he did on his own. If it was a misunderstanding, it was a misunderstanding when they came and approved it as well. And it was only 5 weeks later, I believe someone said it was not approved. One of the exhibits that we did show, it was approved. And then 5 weeks later, they received a letter saying it's not approved. So.
Any more questions from the board for the petitioners? Seeing none? Oh, yes.
Yeah, I feel that the setback requirement was 40 feet is what the required setback requirement. And we can't, as Ms. Lancaster mentioned, you can't possibly legislate every possible condition. And there are some extenuating conditions here, one of which is the fireplace. I don't know if the fireplace would be extended into the setback or not. I don't know that, but that could be another issue here in itself. I'm ready to vote for it, but because I don't think that, it's not contrary to the public interest, and it does not establish or prohibit the use within the zoning district, and the conditions that are set forth here does not cause any adverse effect. To me, it has a side yard condition that is defined as really a triangular small piece because of the setback requirement from Waddles as well as from the main street. So I think there's reason for a variance on it. So I'd be voting for it. I just want to vote on that issue. I don't know if there's anybody else that wanted to talk against it or.
Well, I'm going to open the public hearing. I wanted to give a chance for the board members to ask any questions, then we'll open the public hearing. That's okay. Any further questions for the petitioner? Seeing none, if you could have a seat, and then we'll open the public hearing and see if anyone else.
Thank you.
Thank you. We'll open the public hearing. Anyone that would like to speak on this issue, either in favor of or in opposition to, or is welcome to come forward at this time. Anyone? Seeing none, we'll close the public hearing. Oh, I'm sorry. Go ahead, come on up. Make sure you introduce yourself and sign in on the little sign-in sheet there, please.
I'm Jerome Thompson. I'm the neighbor, and apparently I have a building that's illegal, they said. I have never been told that, but I'd like to see that picture if I may. Is that possible?
What kind of picture are you looking for?
Of my house where the, may I give you guys a?
Sure.
Mr. Chairman,
Mr. Courtney?
I think you should realize we're not going to hear an appeal on your property. We're hearing a different appeal.
I just want to know if I was wrong. I want to do something.
Well, you could stop and talk to the department tomorrow during office hours if you wanted.
Take a look at them. We'll need them back before we leave. It's part of the record.
For him? Okay. Wait for him to go back, yeah. Mr. Thompson, Mr. Neal has a quick question for you here on this.
You might close out the issue of the structure. The item the picture that we saw, that looks like to me a a deck box. That's a freestanding structure that's easily moved. It's not a permanent structure that you have sitting right there? That item that was mentioned was alongside your house. It
The
looks like-
one that I have?
Yeah,
Yes, it's a, just one you can pick up and move.
it's plastic, you buy it at Lowe's.
Right. And the inspector was there and never said it was wrong, so.
I think, maybe there's some arcane rule I'm missing, but I don't, I think we're talking about apples and oranges there. I don't think that's something you should be concerned about at the moment.
Well, there's a couple of things I wanted to bring up, and number one is the corner lots you're talking about. The way I understood that it was the rules that you were reading is if there was a house in between the two corner lots that make that a front yardage, and it went out into the roadway. Isn't that right?
I don't believe so.
Huh?
I don't believe so,
I
but
think that's what
Want me
the
to
inspector,
answer his
go ahead,
question?
answer that, Mr. Evans.
that's why that shed was allowed where it was.
Basically, what the ordinance says, the new ordinance says, is for corner lots, any yard, well, a corner lot has two front lot lines. Basically, any lot line that's adjacent to a public right-of-way is a front lot line. The ordinance goes on to say that a front yard is the open space between the front lot line and the nearest point of the main building. The ordinance also goes on to say that one of the other two remaining yards, one of them shall be a side yard and one of them shall be a rear yard. In this instance, because the house does not meet the minimum setback for a rear yard of 40 feet, it's clearly less than 21 feet, the department had no choice but to consider this yard here the rear yard and this yard here a side yard. Does that answer the question?
Yes.
Okay.
Okay. Now, what I presented to you is just some pictures from this, and I noticed, Michael, you were over there looking at them tonight. The first picture is from the road when you're looking at it. The next one is the same picture. The next one is the lot from my view with the trailer house and that lot. The next picture is after he put up his 6-foot privacy fence, what the view was. And the next one is interesting because when the inspector came and told him he had to get a waiver, about 5 o'clock at night, I'm sitting at my dining room table having dinner, and I hear pounding and sawing going on, and he cut my chain down. Because when I talked to the inspector that day in front of Mr. Martin, he said, well, is this building okay with you? It's the wrong spot. I told him, I don't like the building, I don't like the fence, and I don't like the trailer house. But I said, if they're legal, there's nothing I can do about it. I still don't have to like them. Well, that night, he cut my fence down. So I called him up and I said, what's going on? And he said, if you don't, and there's a few cuss words in there, don't like what I'm doing over here, he said, then you can't hook onto my fence post. Well, so the next day I hired a survey crew, which came the following week and got a survey, and that post was right on the property line, so I had legal right to hook my fence up there. And besides that, before he put his other fence up, I told him I had paid for half of it. Came to find out that was on my property, the fence, so he cut down my whole side fence. That belonged to me. So having said that, I'm opposed to where this is. If you look at the last picture, this is what I see when I look out my window when I'm sitting there eating breakfast, lunch, or dinner. And I think it would, if it was moved in the backyard, and the inspector told me the backyard was the back of the house, not back of the garage. Because it's the dwelling and not the garage. It's a dwelling and a garage, and they're referring to the back as of the house, the structure. So I think the shed is in the wrong spot, and that's why the inspector said it was. But I had to pay $400 because of his excitement about I didn't like something and his foolishness of cutting down my fence. And then I had to also go and talked to some legal advisors, which cost me another $500. So I practically have $1,000 in this thing already, and nothing's been resolved. And I really think if you're going to give this a fair assessment of the whole problem, the inspectors should have been here or should have written down exactly what their reasoning was, instead of letting the lay people just decide what it is. And that's all I have to say. I mean, I will do what it, I mean, I may not like it, but if the council, you people say it's going to be that way, it's going to be that way, I'll live with it. And I won't go and destroy anybody's property in the meantime. So that's all I have to say. Thank you.
So you're opposed to the variance then?
Yes, I am.
Okay. Any questions for Mr. Thompson from the board? Seeing none, thank you, sir. Any more, anyone else that would like to speak during the public hearing? Seeing none, we will close the public hearing and bring it back to the board. Any more questions or a resolution?
Mr. Chairman?
Yes, Mr. Neal.
Mr. Thompson, is it?
Yes.
His last final comments kind of touched on something that was kind of occurring to me early on when I was asking Mr. Evans a question about the drawing. My own personal opinion on this is that I really would like to know from the building official what direction was given. I'm not sure if an error occurred, and to me it doesn't really matter if an error occurred, but I think it's important from that as a baseline, because I think it drives everything that happened. And I'm wondering if perhaps, I know that this means tabling this, but I wonder if that might be best to revisit this in October. That's just my comment.
Any other questions or comments, or somebody wish to either offer a resolution to table this, or do they want to offer a resolution pertaining to the variance itself? Did you want to offer a resolution to table or postpone action on this until October?
Sure, I'll put it out there for discussion. I would like to make a motion that we place this item as a tabled item, let it be picked up in October at our next meeting, date we can research, and at that time, hopefully, we can have a representative or the individual from the building department provide a little bit of additional information that would probably be helpful to the board. I would like to make that motion in just fairness to dealing with this issue.
Okay. Is there a second to the motion to postpone action on this? Mr. Courtney seconds it. Any discussion on the motion to postpone action on this? Mr. Bartnick?
Yes, if I may ask, who would we be asking to show up next week? Both inspectors?
I would be comfortable that we would have either one or both. Just somebody could speak on behalf of whatever information, documentation was provided by the building department. A building official would be, as long as they're educated on the issue and can speak to it, that would be what I would be aiming for.
Any further discussion, Mr. Clark?
I think it would be appropriate for us to hear from city staff on the appropriateness of, I mean, I've been on this board for quite a few years now, and others have been on longer. We've never called an inspector before. It's not that it's unwarranted, I'm just saying I would just like to hear from staff. We did have the gentleman from the fire department the one time, but
Yeah, we've got a letter in our packet that you saw from Steve Burns, the building official, and also Brent Savedant, the planning director, indicating the response and the need to amend this matter before it got to the variance process. Steve Burns was ultimately the one that issued the permit, and I understand that other than, he didn't do the field inspections, but he was the one that actually did the drawing and issued the permit of this drawing. So I guess it's up to the board. Do you want the person who actually did the inspection? Do you want the person who actually issued the permit? Do you want them both?
and Mr. Chairman, just to further note, I mean, if there's a consensus to get more information from city personnel, would it be just as appropriate just to ask, for a written communication with them versus I'm not sure what the city management does as far as employees coming to host our, meetings, if they have paid overtime or comp time. So maybe the same thing would be met if there was a written communication.
Mr. Evans, is a written communication something that would shed more light on this?
Well, I guess my question is, what is your question for the building official?
Mr. Chairman?
Well, maybe, I'm sorry, go ahead.
What I was going to say, the questions I would have is, did the building department actually list the 10 by 10, instruct the guy that if he were built 10 by 10, that would be sufficient? Did they actually approve, those two items? Those are the only questions I would have.
Yeah, Morris?
To speak to that, Paul, and I would probably have to revise my wordy motion, but I would be looking for input that could answer what direction was provided to the applicant. Now, whether that could be done in written communication, or it would be better to have a person of knowledge on this issue.
Well, all I can testify to this is I had discussions with Mr. Savedon and Mr. Burns, because the first thing we wanted to look at was this clearly just a miscommunication. In the discussions with Mr. Burns, he did clearly indicate that he believes, and I think his letter might even say it too, that the site plan clearly shows that the shed is no further east or no further towards the road than the back of the house. Let me just double check his letter right now. And I guess the reason why I'm bringing that up, Alan, is simply because I'm not sure, I'm not convinced you're going to hear anything different from the building official than the things we're saying here tonight. But let me see if I can locate that letter real quick.
While Mr. Evans is looking that up, let me ask Ms. Lancaster a question. From a legal point of view, if city staff screwed up somehow on that, does that give us reasoning one way or the other on how we would, whether we would or would not approve the variance?
I guess it goes back to whether or not you feel it was a mutual mistake by both parties, or whether or not you felt that there was an oversight. I mean, I hate to use, I don't know that anybody screwed up. It could just be sometimes there's just no meeting of the minds. You're saying one thing and somebody's hearing something else. In terms of Mr. Clark's question about you normally don't call in witnesses, in a fact-finding, this board's a fact-finding committee, and I know it's pretty rare, but if you want somebody from the inspection or the building department to come in, I think you're entitled to ask that. You can also ask that the building official come in, and he can leave it to his discretion whether he wants to bring the inspector in. It might be, I think he can talk to the inspector. I don't know that we want to, it depends on what your questions are, and based on what Mr. Courtney said, if you think those questions, you want to hear them in person for your record, so be it. Certainly, I don't know that you necessarily need the inspector, but it's possible that you could bring them in if you want.
Mr. Evans, you had.
And if I could, just in follow-up to my supposition, this is the letter that was sent to Mr. Martin by Mr. Burns, the building official, and the last sentence of the first paragraph says the site plan clearly shows the location of the shed behind the building line and in the rear yard.
Mr. Courtney.
This is the reason I'd like to know if the building department actually told him the 10-foot and the 10-foot.
Yes.
Because while the drawing shows it, the 10-foot and the 10-foot would do something different. And there would be an absolute miscommunication between both parties there. One thinking the line showing it at the tail end of the building was sufficient, and the other thinking the 10 by 10 was.
Well, I'll say this in my mind, after talking to Mr. Burns and looking at the permit, it's possible that both things were said. A, because the ordinance says you have to be 10 feet from any main building, But the ordinance also says, here's what a rear yard is, and you can't be within the rear yard, and Mr. Burns reiterated that fact in his letter. So based on what I'm aware of, we believed that, A, it was every intention of Mr. Burns to have that in the rear yard. B, when we draw a line on this drawing, if I were to draw a line here, and I probably could, I think we can reasonably presume that it could be up to the edge of the back of the house, but no further. You know, honestly, had we issued a permit and something was in the wrong spot, we might have looked at this a little differently, but I think there is justification from the building department that it could reasonably be argued that this site plan shows that it is in the rear yard. And it is 10 feet away from the building as well.
Mr. Neal?
So what you're saying is, from your understanding and researching this to prepare for the meeting, is that you were left with the impression that the building department, while explaining to the applicant where to place his shed, was given information that covered both issues, the dimensions plus the placement being behind the wall, the rear wall of the house. So
Right.
in other words, that's your...
Yeah, they gave him the, you know, I think they might even have a handout on this that basically says, okay, if you're going to put up a shed, you got to make sure it's this distance from the building, this distance from the lot lines, and it has to be in the rear yard.
Well, one reason I'm asking that is because if that is your input and your understanding, then I don't feel the need for my motion.
I just wanted to, yeah, I just wanted to let you know, because I don't think you'll hear anything different from Steve. Not that you can't have him come out. Yeah.
Mr. Chair,
Yes.
if I could add to that comment, since we do have a letter, you can accept hearsay. If this isn't a court, there's no rules of evidence. You can take Mr. Burns at his word that that's what his intent was, and take the petitioner and listen to what they said, and use that as your record. It's part of your record. It's part of your exhibits. And if you feel comfortable after what Paul said, what he learned, this board doesn't have, as I said, rules of evidence, so there's no hearsay here. If you feel comfortable after this discussion and you want to use that information, then that's acceptable too. You don't have to hear it from the horse's mouth, so to speak.
Mr. Stratt and then Mr. Courtney.
I really think that the drawing is totally misleading. It is a bad, bad drawing to begin with. It was totally, I mean, that's not the building department's fault that the drawing was misleading. They interpreted one way, they built it another way. The 10-foot, the proportions are totally inaccurate. Everything is inaccurate on it. Now, how can we blame the building officials? I think that's wrong. And I really, you know, I agree with Ms. Lancaster. You can't possibly legislate every possible condition, as I stated before. This, I'm going to bring up to the Planning Commission, because I want this to be resolved. This is not a good, this is an excellent example, I think, of it not being right. It's too ambiguous, I think. I think we've got to correct that aspect of it. This should never have come up, in my opinion. I mean, that's the way that I feel about it. You know, the setback requirement is 40 feet. He's 45 feet by the drawing, or by the inspector's drawing. I mean, he's still within the setback requirement, but yet the building is dictating the setback, which doesn't make sense. What is the intent of that? What was the intent? I mean, why was that done? You know, what was our you know, the intent when we drafted this up? To protect what? And that's what I really am concerned about. I'm sorry.
That's okay, and just to clarify, the rear yard setback for main buildings is 40 feet. The rear yard setback for a building like this shed would be 6 feet, just so everybody's aware.
I'm sorry, I didn't catch that.
The rear yard setback for the house
Yes.
is at least 40 feet, but for a detached accessory building like this, it's only 6 feet. So in theory, there's a lot of room on this property to build. And I apologize if I wasn't clear about that earlier.
Yeah. No, I understand that. But
Okay.
also, as you pointed out, there are two front rear yard setbacks on this building too, or on this site.
Yeah, he's got two front setbacks.
Yeah, so you know, he's limited.
Right.
So he had to, you know, he had not much of a choice. I don't know. I don't think it's anyone's fault that we should be blaming anyone. I think it's a situation. I think that if there's anything that was wrong, is that the building department should have not accepted that drawing, if it's not accurate.
And Mr. Courtney?
Yes, I would think in addition to the comedy of errors, the final approval, which was given, and in error, adds to the confusion. That means the building inspector that went out to approve probably looked at this, or knew the 10-foot, but didn't realize the rear yard setback.
Mr. Chairman?
Mr. Neal?
I would ask on a point of order issue, since I made a motion that I don't even agree with anymore. What is the practice?
Well, I believe since I
Do we have to vote it down?
recognize that the motion had been made and seconded, it would probably be appropriate if you've changed your mind to vote against your motion. So any further discussion on the motion to postpone? It sounds like the board is leaning against postponing, if I read your minds and head knocking correctly. So I guess, unless there's more discussion on the motion to postpone, we'll take the roll call on the motion to postpone. If you want to postpone, you vote yes. If you're against postponing, you vote no.
Motion to postpone, Mr. Fisher?
No.
Mr. Neal?
No.
Mr. Lambert?
No.
Mr. Stratt?
No.
Mr. Bartnick?
No.
Mr. Clark?
No.
Mr. Courtney?
No.
The motion to postpone fails. Is there another resolution someone would like to offer? Mr. Bartnick?
I wanted to ask a question.
Sure.
If Mr. Evans, if you could please put up on the board
Yes.
the next preceding drawing, I think, page number 3 on your set. Maybe page number,
All right. What's the drawing of?
well, it's, this looks to me to be this last page of the, it's the page where it appears to be a photograph and it's got the signatures of the City of Troy Building Department approved by.
Got it. That letter?
No, not a letter, it's a photocopy of an aerial photo, which is at the top of the page. And then a stamp that says architectural features shall not encroach, et cetera, approval, et cetera.
22.
Page 22 on my record of 61.
That's it.
Thank you. So is this the piece of paper that's signed by the city when the permit is issued? Is my question. At the bottom there. Is that June 8, 2011?
Yeah. Yeah.
Then,
That's part of the building permit record.
okay. And so if you look at, if I'm looking at the top of the page there, and again, it's a photocopy of an aerial photo, but it appears at 3954, an attempt at a box is drawn there, which I assume is the shed. Part of it is west of the rear of the building. Part of it is east of the rear of the building. And if you compare that to, which kind of goes along with the idea that he built it as he was allowed to build it. And then if you look at one of the photographs that was submitted by, I guess, the member of the public that lives next door, the drawing from his yard looking at the shed and the trailer before the privacy fence was put in, you kind of see that that's pretty much in conformance with that drawing. Because part of it is to the west of the building line, part of it's, the majority of it's to the east of the, west and east of the building line. Which to me kind of goes in favor of the idea that he did what he said he was going to do. So that'd be my comment.
Any other discussion or anyone wish to offer a resolution? Mr. Stratt almost had a resolution earlier. I don't know if he wants to offer that or not.
I don't feel I'd be proper doing that.
Mr. Neal?
I do have a question. I guess it would go to Ms. Lancaster's I think what somebody used the term comedy of errors. I'm asking kind of a liability question. If we were to say no to the request, it would seem to me that one of the parties involved would have cost incurred with moving this structure, and a legal case to look for recourse for compensation for the cost. Just so I know, how does this play out? What typically has happened in the past? Is there anything you can speak to? Do you know what I'm asking? I think there'd be a
Mr. Chair?
homeowner that would feel injured and looking for recourse.
It's pretty rare that something like this happens, that there's compensation involved. Most of the appeals are just based upon the appeal itself, and no building has gone on or anything of that nature. Probably it could be included in, if there was an appeal, you can include other counts in that appeal, and it would basically be up to a judge. There would probably be some allegations about who, was there an agreement, who did what, and once the judge made those factual findings, if the judge felt that the city had done something incorrectly, they might. However, case law does not, we have something called governmental immunity, and cases are loaded with mistakes made by inspectors, and rarely does the court, they understand that mistakes get made, and if it's something that was a mutual mistake, then that would probably be in our favor.
Any further questions or motion from any member of the board here?
Mr. Chairman,
Yes, Mr. Bartnick.
I'll make a motion to approve the variance on finding that there are practical difficulties and hardships as required under 15.04 of the ordinance, including a number of the factors that have already been discussed this evening.
I'll second it.
Been moved and seconded to approve the variance request. Any discussion by the board members on that resolution? I would indicate that we have, as far as public opinion, we did not receive, or we received via email or by letter. It looks like we have a petition that was circulated by the applicant. It looks like there's about 11 signatures on that petition in favor of the variance. We have 2 emails or letters that are in support, 2 that oppose, and 1 I'm not really sure of by looking at whether they support or oppose. So I guess we put that in the undecided category. Any further discussion by the board on the resolution? Mr. Clark.
I'd just like to point out that I know that the public hearing was closed out at a certain point, but the gentleman who was the abutting property owner had his hand raised. Apparently he wanted to insert some more information. It looked like he had a quick comment, and he had his hand raised quite a few times, like 4 or 5 times. I'm not sure if it's appropriate for him to say a few more words or not, but he was trying to get your attention earlier.
Yes, I saw it. If the board would like to reopen the public hearing, that's totally your decision if you want to hear more testimony. Anyone on the board wish?
We've had enough discussion on this.
Okay. All right. No one wants to hear, so we are ready. You had a comment, Mr. Stratter? Okay. Any further discussion on the resolution? Seeing none, we're ready for the roll call.
Mr. Neal?
No.
Mr. Lambert?
Yes.
Mr. Stratt?
Yes.
Mr. Bartnick?
Yes.
Mr. Clark?
Yes.
Mr. Courtney?
Yes.
Mr. Fisher?
Yes.
The resolution passes. You have your variance.
Can I have a copy of those photographs?
Sure.
This gentleman,
Okay, we're back to the second variance request. This is from Edwin Wadika at 1927 Sparrow Court, a variance to allow a 19-foot tall accessory supplemental building, which is a playhouse in the front yard. Accessory supplemental buildings are permitted only in the rear yard and shall be no taller than 14 feet in height. Mr. Evans, could you present this case to the board, please?
Thank you, Mr. Chairman. This property is located in a residential district south of West Waddles and east of Coolidge Highway. More specifically, it's at the corner of Sparrow Court and Edgemont. The property is zoned single-family residential, as is all surrounding property. And this is not the one I wanted to have up. Hang on here. Now, the subject matter involves the construction of this playhouse, which is defined as an accessory supplemental building under the city's zoning ordinance. The ordinance prohibits the height of accessory supplemental buildings over 14 feet in height. This building is approximately 19 feet in height. And the ordinance also requires that accessory supplemental buildings be located in the rear yard. The yards adjacent to both streets are considered front yards from a distance from the lot line to the nearest point of the building, and this existing structure is located within the front yard along Edgemont. So the two variances they need tonight are, one, to keep that accessory structure there, and two, to allow it to be 19 feet tall when the ordinance permits a maximum height of 14 feet.
Any questions for staff? Mr. Bartnick.
The first question, I guess I have two questions. One is, was the structure that was there before is described as, is that something that was required to have a building permit, or is it a temporary structure, or is it a structure that's regulated by the zoning?
I don't know. I'm not familiar with what was there before. Perhaps the applicant can give us some testimony as to what was there before.
And then the second question, three questions, is the definition of the height of the building. Was the original building that was there, or structure that was there, hesitate to call it a building, was that within the height requirements for that type of a structure?
I'm not sure. Perhaps the applicant could address that.
So there's two components to the variance. One is the height of the structure, and the second one is whether it's in a side yard? Or,
whether we can allow it in a front yard.
which gets back to the question we had on the last case. Is this a side yard, a front yard, or a rear yard?
This is a front yard.
Why is that?
The ordinance defines the front lot line as a line separating the right-of-way or the street from property. In this instance, there's two front lot lines, one along Sparrow Court and one along Edgemont. The ordinance goes on to define front yard as the open space between the nearest point of the building and the front lot line. So by that definition, we have essentially two front yards. The ordinance goes on to say that the remaining yards, one of them is a rear yard and one of them is a side yard. And that the rear yard cannot extend into the front yard. So in this interpretation here, we've got a front yard along Sparrow, a front yard along, whatever the side street is. I can't remember if it's Edgemont or, what is it? Edgemont, thanks. And because the rear yard setback in this district would not accommodate this yard over here being called a rear yard, we have no choice but to call it a side yard. That's the westerly yard. So therefore, this would be the rear yard here. And the ordinance specifically says that a rear yard cannot extend into a front yard. So that's where we have this red line that I drew differentiating the front yard from the rear yard.
May I ask a follow-up question? Is it possible to also interpret it as a front yard is on Kristen and the Edgemont side is a side yard and the property west of the house is a side yard and the rear yard is as you've indicated? But then again, under the B and C sections or sentences that I cited on the last case, that the side yard on Kristen could be interpreted to be a rear yard.
Well, let me show you the definitions, if I could.
Please.
Thank you. Now, the definition of yard includes the terms lot line, so we have to start with the terms lot line. What are our lot lines? And so I'm going to show you the definition for lot lines here.
Excuse me, before you get too far, it's not on Kristen, it's Sparrow and Edgemont.
Edgemont, yeah.
Oh, thank you.
Yeah.
Thank you.
Lot line, the line bounding a lot is defined in the ordinance. Now, just for summary purposes, I'm going to skip what I don't think applies. In the case of a corner lot, both lines separating said lot from the street shall be considered front lot lines. Any question there before I proceed? So, we've established that the front lot lines are the lines that separate the roads from the property. So when we go to the definition of front yard, a front yard is an open space extending the full width of the lot, the depth of which is the minimum distance between the front lot line and the nearest lot line of the main building. So, we've got a front lot line here and a front lot line here. The front yard is this distance here and this distance here.
Why did we have two front lot lines on this property and not two front lot lines on the other property?
I thought I answered in my clarification comments that we did. I apologize. Did I? Okay, yeah. We did have two on the other one as well.
Any more questions for staff? Just a quick follow-up. This is Mr. Bartnick's question about whether or not there was a previous permit for the structure. And maybe the petitioner can answer this question more fully when he comes up here. But if this was originally some type of a play structure, whether it was bought from a manufacturer or kind of a homemade play structure, the city ordinance does not require any kind of a building permit for a play structure, does it?
Not normally. You know, there's so many kinds of play structures that you could just overregulate something to death and really, are you going to really meet the intent of regulating every little swing set or teeter-totter that goes up? There's play structures that are not permanent that you can move around on the property, and I'm not confident that the ordinance was intended to regulate those, but in this instance, due to the height and the size, if somebody were to put an outbuilding of that size there, perhaps similar to what we saw in the previous case, we would certainly ask them to come in for a permit.
Any further discussion, or I'm sorry, questions from the board for city staff? Seeing none, we'll invite the petitioner to come up and be sure to sign in. And Mr. Wadika, I believe.
Yes. Thank you.
I believe you brought your daughter with you. She was pictured, I believe, in your application, wasn't she?
Yeah, they wouldn't let me get away without jumping in the photos. I apologize about that.
That's okay.
The play structure did exist, and it did have two gables roofs on it. Basically, my kids were asking for a tree house. We didn't have a tree in a conducive area to build the tree house, so I said, I'll take the two roofs off of the current playhouse, build what I consider a tree house. It's a fort. If you see right there, that one picture, that's the only spot you can see the tree house from. The rest of my yard is completely surrounded by tall trees. It's really covered. I was going to stain it dark brown so it would blend in, trim it out really nicely. It's not a permanent structure. When the kids are 14 years old, another 4 years, I will remove it and take it down. It was nothing more than intended for a place for my children, the neighborhood kids to play. I had letters from all of my neighbors stating that they're fine with it. My house is the house all the kids come to play. And it wasn't meant to slight the city. I didn't know it was a structure. All I thought it was a tree house for the kids to play. Had I known I needed a permit, I would have. And I don't know of a neighbor that complained, but apparently when I was talking to Mr. Evans, there was someone who called and had issue with it. I've yet to find that out. I mean, our neighborhood social is at my house, so it's a community house, and I'm a good neighbor, and I didn't know I was breaking any city ordinances, or else I would have gone ahead, because the structure was already there.
Any questions for Mr. Woodika? Mr. Courtney?
Yes. Do you know where Capettos live compared from your house?
I have no idea where they live.
Do you know enough to know whether they're one of the adjacent houses?
They are not one of my adjacent houses.
Okay, thank you.
Yes, Mr. Stratt?
The playhouse that you had originally there, is there a foundation for that?
There is not.
There is not.
It's built on 4 sets of 4x4s, and it's structured up.
What makes you think that this is structurally going to be sound?
We've had 4 of the greatest windstorms we've had in 40 years, and it hasn't moved. I was a builder through high school. My father was a builder. I'm son of a builder. I built houses going through college. This thing is sturdy. If I'm allowed to continue with it, I will put a couple more cross braces to shore it up this way, but as far as north to south, it's shored up. And then with, I was gonna put trusses, which is why the back wall's at 7.6 and the front wall's at 7 foot. I was gonna put that clear plastic roofing on it, which would shore up the top. I put the windows in for the wind from east to west. So it's a very structurally, and I don't have a problem with the building inspector coming over. And when he actually came over, and what I believe happened is the lady across the street is having her basement remodeled, and the building instructor saw it. And I wouldn't blame him for asking a question. And he came over and he said, "Your husband looks like he knows what he's doing." And as you can tell, everything's 16 inches on center. It's got cripplers. It's got wind braces on it. It's got TX111 on the exterior. So it's a sound tree house. I would never put my children in jeopardy, especially after what happened when we moved in the house. So I wanted to make something very safe but fun for them and the neighborhood kids.
So you're saying you got the building permit for it?
I didn't, and when I went to apply, after I found out, I went to the city and they said, we can't give you a building permit because it doesn't meet the setback requirements. So first you have to go for a variance, and then from there you have to apply for a building permit. And I said,
so you're confident you can get a permit for this?
with the exception of footings, I mean, if he lets me dig post holes and put 2x12s across, sure, it'll be shored up, and I could put 4 post holes and run them up. As you see, I ran parallel beams, and I could run a 4x6 up for support all the way from ground up, which should meet code for something like that, which has no real bearing weight.
I don't know if I appreciate, you're being a builder, but I have concern visually, as I see it, calculation-wise, that the wind loads on this thing, it could topple very easily.
Okay.
Because there is no bracing underneath. You don't have any bracing to protect it from the uplift on any of the corners. Now, I don't know, as I said, calculations would have to be done, but it looks like to me it'd be kind of dangerous. And I know that you don't want to do anything dangerous for your children either. So I would agree, and I just wanted to caution you on that, my opinion.
All right.
At any rate, what are the hardships that you would, as we pointed out before, what would you consider the hardships to be?
If it were placed in the rear of the yard, according to the city ordinance, if you do a panoramic view right there, our entire neighborhood, my house, all the way to the end of Coolidge, is all open view. All of us share, there's no fences, so it's a complete straight open view between the houses that back up all the way going to Coolidge. If I were to put that into the back of the yard, my neighbors, I believe, would have the same issue as that gentleman who was concerned about the shed. Is it becomes an eyesore. It's sitting smack dab in the middle of the yard. Where it's located right now, it's surrounded by trees. Only spot you can truly see it is pulling into my driveway, and that's the only visual spot you can see that play structure. Outside of that, There is no way. I could bring a bulldozer and lift it up and set it in the center of my yard, but I wouldn't do it to my neighbors because I wouldn't want to lower the value of their homes by having anyone want to come and look at this, and I'll call it a monstrosity, sitting in the back of my yard.
But it can't be seen in the summertime.
It can't be seen in the summertime, it can't be seen in the wintertime. They're pine trees that surround my whole yard. See? It's all pine trees that surround that whole street side scape.
I see. Yeah. Okay.
Any more questions for the petitioner? Mr. Courtney?
Yes. Basically, what you're saying is that having two front yards, if you didn't have the one front yard, that would be in the rear yard. If you didn't have the one street going by you, that you're addressed off of Sparrow.
Correct.
If the other street did not go by, would you be in the rear yard?
Yes.
Okay, so having two front yards is kind of a detriment there. Thank you.
Mr. Neal?
Yeah, I just have one question for you, sir. Is I want to make sure, because photos sometimes are not good at showing the type of species of trees. When I look at picture 47, can we put up 47, or at least it's 47 in my art packets? I see the pine trees, but I also see what I think is a maple tree, kind of in the center. It's a photograph. It's the
Yeah,
last.
that was the one I zoomed in on.
Yeah, to me it looks like if that's a maple tree, a large tree there, in the winter, your neighbors would see it.
That's on the street.
That's on the street.
That is on Edgemont.
Okay.
That's a view from Edgemont, zoomed in.
Is there a neighbor on the other side of Edgemont?
Nope,
Okay.
there's no neighbor there.
Okay. Thank you.
Mr. Bartnick?
Go back.
I had a few questions. Looking at page 40, though, of 61, which is an aerial, I understand what you're saying about the common area. But looking at page 40, I mean, there are trees going back from your yard to the next neighbors to the west and then farther to the west. And also, this particular structure is east of the entrance to the garage as opposed to on the last case where it was actually behind a building. This particular structure is not behind any building at all. If it was behind the front of the garage in that same little L-shaped area, that maybe I wouldn't have a problem with it being in this front yard, et cetera, the side yard, the rear yard, whatever it is. But this is definitely visible from Edgemont when you drive by, especially at that height. So that's one of the key problems that I have with it, that it is visible from Edgemont. And secondly, it is to the east of the garage, out in the open area there, even though it is hidden by trees, it is visible from Edgemont, not just from your driveway, which is your property, but it's visible from Edgemont to somebody driving by, especially at 19 feet. So that's what my concern is.
Any more questions for the petitioner?
Well, what are the hardships in terms of, if any, in terms of the height of the structure, and then also in terms of being required to move it if it's not already on a foundation, a concrete foundation?
Well, I could bring a bulldozer or a crane in. I have $1,300 into lumber into it already. I could bring a bulldozer, rip down my trees or my arborvitaes to get it back there to pick it up. An off-road forklift. I could pick it up and put it into the back of the yard. While I have it up, I could cut it down 4 feet if need be to meet the 14-foot requirement. Given to go through all that, I wouldn't wreck my yard to do it. I mean, I just wouldn't go through that. I wouldn't incur the cost to go through that. I've put in over $100,000 into my house to make it look nice, and I'm not going to tear apart my yard for something that was truly meant just to be a place for my children to play.
And they can act on them separately.
Thank you.
Any more questions for the petitioner? Seeing none, you can have a seat, and we'll open the public hearing.
Actually, I did have another question for the petitioner.
Come on up, back up.
I
Sorry.
guess in fairness, I don't know if you get the communication, but there was an opposition, and it indicates in the opposition that she's a homeowner in the subdivision. She's absolutely opposed to the 19-foot. I just want to read this to you so maybe have some kind of a response. That she's absolutely opposed to the 19-foot playhouse being able to remain on the above-mentioned property. It is visible from the adjacent road. It is too high, and I'm paraphrasing. It is an overhead addition to an already existing play structure, and it appears to be very homemade and unsafe. She feels it is an eyesore to the neighborhood as well as a safety issue. And in addition to the height of the structure, it creates potential privacy issue for neighboring homes seeking privacy in their yards or homes. And again, I'm sure she's referring to the 19-foot high nature there. Do you have anything to say?
This is the one I asked him about the person, and he says they don't even live abutting.
She lives in the
So,
same subdivision.
yeah, she
So-
lives in the subdivision,
Right.
but if she's not abutting,
Well, it's
her
the main.
privacy isn't being invaded.
Well, that's true, but she's got the right to make a comment. I mean,
Well, right.
and it's a street going in and out. It's the main street going in and out of the neighborhood. Is that correct?
Right, and I'm sorry, I did get signatures from all the neighbors to the left, except the one on the corner wasn't, and all the ones across from me, all the ones on Edgemont, the ones behind me as well. So anybody that had a direct view of the play structure on a consistent basis, all the way down the street, and I asked, do you have an issue with height, location, size of the play structure? None of them said, no, gosh, you have kids, they should enjoy it. And so I don't know where the lady lives in our subdivision, but she's not one of the immediate people who would adversely affect in the neighborhood.
The petition here says that we are aware that it does not meet the 40-foot setback as required by the ordinance, but we do not have an issue with the structure or its location. So it doesn't specifically address the fact that it's the height of
The height was never
structure.
brought up to me until I received the letter. When I talked with Mr. Evans, the 19 feet was never brought up until afterwards when I received the letter for this hearing that it was 19 feet. And I didn't know that.
Thank you.
Any further questions, Mr. Stratt?
You know, maybe, and I say maybe in a stretch, because you have two front-back setback requirements, maybe that location might fly, might not, I don't know. But the height, what is the limitation? And how can we justify a variance on the height? We're setting a precedent. I don't see any hardship.
And there isn't any. The height thing was, I made it 7 feet tall so I could stand in it. And I took.
You're not going to be in it, the kids are.
Well, I'm going to go up to get them, make sure they're behaving. I just took the current structure that was there, the roofs that were up there, I removed those. I went off of what I felt was the safest point to go up.
I understand, but how can we justify that as a hardship of some sort? How can we justify that?
I don't believe you can.
At least you're honest. I'll tell you, I give you credit for that. You're really honest. That's one thing that a lot of people come before us are not.
Any more questions for Mr. Whitty?
Would you be willing to cut it down in any way?
I could figure a way to do it. I mean, I think I could get some jacks, support the base because of how I built it. I think I could support the base, get some jacks, and cut it down a couple of feet.
Yeah.
And drop it down.
Conform?
I'd end up losing the swing set if I did lower it down, because if you see from the side picture where the swing set comes through, so I'd have to ask my kids whether they want the swings or the fork. So I'm sure where there's a will, there's a way. I could probably bring it down a couple of feet.
So what I'm hearing you say, the hardship as it relates to being a corner lot, you could actually justify, or that would work. But as far as the the height you would have to modify, and you're receptive to doing something along those lines?
Sure, if you so ask me to.
Opposed to getting denial,
Correct.
total denial.
Right.
Is the height, I'm sorry.
Mr. Courtney?
Yeah. Why not just don't make it 7 feet high? Can you cut it down to 5 feet without then having to lower everything? Or 5.5, I
Yeah,
assume the kids
I
can
could-
walk in it at 5 feet or 5.5. and-
Right. I could probably cut the walls down.
Okay, at least you'd have more than one
I would have
option.
options, correct.
Yeah.
If I had to get it down, is 17 feet the requirement or 14? I don't know what the,
No taller than 14 feet.
14, but
And for the clarification of everybody here, we measure, for example, if there's a peaked roof, we measure the midpoint between the peak and the eaves.
Right.
So there is the possibility that depending on how, if he needs to redesign and rebuild, he could design it so a portion of the roof could extend over 14 feet in height.
Any more questions for Mr. Wadika?
yeah, I was still thinking of leaving a couple of feet variance.
Yeah.
But
But right now, you're at 17, 18 feet to just the bird's mouth.
I'm at 18 feet to the highest point.
Yeah, no, to the highest point of your wall.
Correct.
Oh, is that the roof that you're
Yeah,
talking,
that's
new
the
roof?
That's to the roof height. Right there's,
You got a 7-foot rise on that roof?
it's 7 foot on one side, 7'6" on the other side. That's my roof. So that's a peak of my roof. See, it's a shed roof. It's a 6-inch slant, so the snow would slide off.
In the
It's not a-
photograph, is that 10 feet high? In your
That's-
photograph?
That's how high the base of the flooring is 10 feet off the ground, because that's how tall the play structure was,
10 feet off the ground.
10 feet off the ground, right? So
Now, on top of that, you've got your floor there.
at the 10 feet 6 is where my floor starts, right?
Okay, then you've got, what, 7 feet?
7 feet, correct.
So you're at 17 feet.
17 feet, correct.
And we are at 14, and that's just to the bird's mouth, or to where you're going to have your truss?
The truss is at 7 feet 6 inches. So that will be,
Add your roof, your truss on top of that,
would be another 5.5 inches.
and then you average that out as we're just talking about, 2.5 feet.
What's,
If it's 5 feet to the
I'm
top,
not
you
peaking
go.
it. It's a shed roof, it's a flat
Oh,
roof.
wow. Well, even that, you can cut it in half, though. You're way, way high. You're going to have to,
Yeah, I'm virtually 3.5 feet high off of 14.
yeah,
Right.
but you're willing to do that.
If that's what it's going to take to keep it, then I'll figure a way to do it.
Okay?
Any more questions for Mr. Wadika? Seeing none, you can have a seat, and we'll open the public hearing in case anyone would like to address us on this issue, and maybe one potential person. We'll open the public hearing. Anyone who would like to speak to the board is welcome to come up. Be sure to sign in and tell us who you are and your relationship to the property in question.
My name is Charles Jensen, and I'm sort of a friend of Ed's. I mean, we don't barbecue together and that sort of stuff, but we know each other. And I live about 200 feet away to the south. And I am a original of the subdivision, some 30 years ago now. And when we moved there were kids all over the place, because we're all young families. Our 3 kids were there. Then, of course, it rolled over and they moved out and what have you. And now we're beginning to get more kids back in there. And I think that it's a magnificent structure. And if you go stand out on Edgemont, the street, and look, you can't see it because the trees are higher than it is. And there was an argument or a statement that it was in the front yard, which of course it's not. It's in the backyard. and I'd like to see it stay there. We need more kids. We need more kids playing in the area.
Any questions?
Any questions?
All right, thank you for speaking. Any further public members who would like to address the board? Yeah, don't.
I'm supposed to, pardon me?
Did you leave anything up there on the front or not? Your glasses? Or you got 'em? Oh, it's not. Okay, all right. No one else wishing to address the board, we'll close the public hearing. And I would indicate, I think we already discussed it kind of during the questions, but that we have a petition, it looks like about 8 people signed it in support of the variance, 1 letter in support, and then 1 letter opposed. I believe that's the correct overview. Anyone from the board have any more questions? Mr. Evans.
I'd just like to clarify that the applicant is correct, that the city did receive a complaint regarding, actually I took the complaint, it was an anonymous call, concerned about the safety of the, what they described as a fort being built on top of an existing play structure. So that's why the city got involved.
Great, thank you. Any questions, comments, resolutions anyone would like to offer from the board? Mr. Bartnick?
I'm concerned about the safety of the structure including based on some of the things that Mr. Straight indicate. I'm also concerned about where's the evidence of the hardship, especially given the fact that the structure that is sitting on is a, quote, temporary structure. So you have a lot of difficulty saying that there's some kind of a 15-year history or of a structure that's there when the structure that's there is a temporary structure. It's a play structure. I got real problems with this one.
Any further? Mr. Evans?
I just have a comment for the board. Although it's written up as one variance request, it is 2 different ordinance sections, and the board could address each section in a different way if they chose to.
Thank you. Any further discussion or anyone wish to offer a resolution from the board? I know, listening to the information, that I'm supportive of that part of the variance request, which would be the rear yard setback or the front yard setback, because it is a literal enforcement would involve some practical difficulties because of the fact it's a corner lot. But I also believe that the asking for the height higher than 14 feet, I just don't believe any information was offered along that line to justify the board giving a variance. So I would be willing to offer a motion and have the city attorney correct me if I'm wrong, a motion to approve the variance request for the allowing it in the within the setback only, based upon the practical difficulties of being on a corner lot.
Support.
Mr. Courtney seconds the motion. Any discussion on that motion? Mr. Bartnick?
So is that, your motion is just dealing with the front yard issue?
Setback.
We're not dealing with the height
Correct.
on this one? Okay, thank you.
Any discussion on the resolution? And I ask city staff, do you believe we have enough information here if this passes to provide substantiation for the resolution?
You've made a good record.
Okay, all right. Any further discussion? Mr. Bartnick?
I would just add also for this part of the discussion and this part of the motion, I think it's in several of the photographs. There are pretty thick hedges there that go up about 6 or 8 feet. And I can see where a layperson would say that that is a side yard or a backyard on this particular lot as opposed to a front yard. Thank you.
Thank you for adding that to the record. Any further discussion? Seeing none, I guess we're ready for a vote on the resolution to approve that part of the variance for the front yard setback.
Mr. Lambert?
Yes.
Mr. Stratt?
Yes.
Mr. Bartnick?
Yes.
Mr. Clark?
Yes.
Mr. Courtney?
Yes.
Mr. Fisher?
Yes.
Mr. Neal?
No.
The resolution passes. You have a variance request approve for the part that has to do with the front yard setback unless somebody else from the board wishes to offer another resolution having to do with the height. I think you'll have to deal with the height issue as far as bringing it down within the city's ordinance provisions. Yes,
I have a question.
Mr. Fisher, yes.
Thank you, Mr. Chairman. Would the city require a permit if he's going to be putting a, is that considered a permanent structure or a temporary structure that he's putting up there?
Well, it's considered permanent in the sense that we really don't have a definition for temporary, so yes, we would look at it as a permanent structure.
So he'll need a permit for that?
Probably.
Okay, then I'd be more comfortable if at least an inspector's going to be there and the city will look at it to make sure it's structurally sound. Okay.
Mr. Courtney.
Yes, I personally have no problem with it being still over the 14 feet, but not going to 19. And I'm just wondering if anybody else has the potential of changing, I would want to table that section to see if he can adjust to meet the 14 and give him a chance to come back if he can't. In other words, I'd hate to see a 3-foot high or a 2-foot high structure.
So you're suggesting a possible resolution to postpone action on that part of the variance request, give him the opportunity to talk to city staff to look at a possible,
correct,
how high you would have to go to meet the code and then how much higher you would have to go possibly to get a variance. That's what you're suggesting?
But I'd only want to table it if anyone else was willing to look at it later. In other words, if you've already decided that 14 is sufficient, there's no sense tabling it.
Mr. Stratt.
Yeah, I would entertain the possibility. The only thing that I have real concern with is the structure itself, and by it being lowered, I think it would certainly enhance the structural capabilities of this structure itself. And I really would like to make sure that, I know that even decks right now, we are asking for permits on decks. So there's no reason why this would not be required to have a permit. The thing that I'd have a problem with is I don't think they'd issue him a permit, or he'd have to have a drawing if in fact it doesn't meet the code or the zoning ordinance. So, which comes first? So I think he needs the approval process. I think that I would entertain the possibility of a couple of feet anyway, give him a couple, instead of 14, go with 16. I don't know what it would do with his roof. If he went 7 and 7, 7 foot clear, 7 foot height, that's 14 feet right there. And then if he went with a shed roof that pitched 4 feet, the average is 2 feet. We'd give him 16 feet instead of 4 feet. Maybe I think I'd go along with something like that. If that's what you're looking for.
Yeah, but I'd rather see if he can meet the 14 first, and then if he can't.
That'd be pretty hard for him, I think, but I don't know.
Yeah, I mean, there's no reason, I'm sorry, I didn't mean to speak out of turn.
Go ahead. All right, go ahead.
I can't conceptualize of a toy structure, of a play structure, having a practical difficulty in exceeding the 14. I just can't see a set of circumstances where it would be justified. We're not talking about a house for humans or an addition for humans. We're talking about a toy structure. I can't see any factual scenario where it can be met. I'm sorry.
Mr. Neal?
Yes, the comment I would have is the reason why, and it ties partly into why I cast a no vote, is that I am very concerned about the structure that's going to be built and changes that are going to have to be made in order for it to get a building permit, which I'm sure the applicant will be able to work out. I can see why with the hedges and such that it passed, and for that I have no argument or complaint. However, I would say, or my opinion is that we're certainly meeting the applicant halfway, and I guess I don't see an argument coming through that'll make me feel that exceeding the 14 feet or 14 and a half, whatever the exact dimensions is ever going to really carry any weight with me. It may require the applicant to spend a little more money, maybe to re-engineer some items, but I think at the end of the day, he's going to be able to get what he wants for his family and still we aren't going to have to skirt the rules, so to speak, with a certain percentage above 14 feet or whatnot. And again, the shorter that it is, I think the stronger that it's going to be. And it's not going to be as much as a wind sail. So I have to echo Mr. Bartlett's opinion in that I don't know that I could ever get comfortable with something going above 14.
You know, that's,
Any further commentary from the board members? Seeing none, it looks like Mr. Waddyka, the good news is you have the variance as far as the location. It doesn't look like the board is willing to consider going higher than that, but so your kids are going to have a great play structure. It's just they may have to sacrifice on the swing height there, so.
Mr. Chair?
Yes.
I hate to interrupt, but I think for clarification purposes, because your motion didn't include a motion to deny Part 2, that if that's your intent, if somebody would make a motion, just so the record's clear what we're doing, that would be very good of you. Okay.
Would somebody like to offer a motion, Mr. Bartnick?
sure, I'll make a motion to deny the request for the variance for the height over what's allowed by the ordinance.
And that's seconded by Mr. Stratt. Any discussion on that resolution? Seeing none, we're ready for the roll call.
Mr. Stratt?
Yes.
Mr. Bartnick?
The yes vote is to deny the, thank you, yes.
Mr. Clark?
Yes.
Mr. Courtney?
Yes.
Mr. Fisher?
Yes.
Mr. Neal?
Yes.
Mr. Lambert?
Yes. Motion passes, so you have that part as far as the location, but the height, the board is not willing to approve that variance.
You have a flat roof.
Okay, next on the agenda is communications. We have a distribute the final rules of procedure, which was in our packet, as well as the electronic version of the city attorney's comments on variance standards. Anything in addition to that? Is it possible that we could get maybe those two documents as separate
Yes,
electronic documents?
most definitely.
Okay, great. Thank you. Any further communications? I see we have some information from the Michigan Planning Association. Miscellaneous business, any miscellaneous business? Seeing none, no public, it doesn't look like we have public comment tonight. And with that, unless anybody has any other issues to bring in front of us, we are adjourned.